All right, so today we're going to make the final conclusion video of the national filing in regard to the status correction blueprint. And this is it right here. It's 2 pages. The first page, as you know, deals with the national filing. And the second page deals with what we're going to call the state filing or the secured party creditor filing, the business filing. And that'll be in the state that you live in or maybe the state that you're born in. The national filing, which we start at the top, where should you file? And of course, this is not legal advice or anything like that. Just a researcher sharing with you according to my research. Now, the first question of where to file, we've chosen the initial designation to either be Puerto Rico or Maryland. Maryland bordering the District of Columbia, which is the United States, and Maryland also recognizing in their commercial law international contracts. So we either choose Maryland as a national filing or Puerto Rico. Puerto Rico uses, let's click this here and take a look. They have their own flag, if you will, their own seal, demonstrating their sovereignty. Further, Puerto Rico is very specific in recognizing Article 8 filings, which is what this national filing is. It's a filing that deals with the security entitlement instead of a secured party by way of a security interest in a contract, like Article 9, secured party creditor. This is more security entitlement registration under Article 8. And Puerto Rico recognizes Article 8 filings, whereas in the rest of the 50 states uniformly recognize the Article 8 and Article 9 filings, or something to the degree like that. There's always something special about Puerto Rico. People that research this type of stuff, you know that. But to follow along with what I was just talking about, and it's very important that you read this reference, the reference that says... reference number 5 down here regarding Article 8 and book entry and direct versus indirect holding. And this is it right here. Memorandum. There is so much information in understanding the differences between Article 8 and Article 9 filing in this reference. It talks about indirect holding versus direct holding. The goal for us, of course, is to be in the direct holding system. This means that we can directly benefit from the securities and the assets that are indexed in our estate. Right now, we're not really benefiting because we're benefiting indirectly. Hence, we're in the indirect holding system, meaning that trustees, intermediaries are administering a blind trust and they're managing our beneficial interest for us. So I think that's also what they used to call the blocked system for the people that were studying this stuff several years ago. Now, okay, so these are the reference material, and the most important ones is questions and answers about trust, what you should get out of this document right here, aside from the basic information of what a trust is, who the grantor is. And by the way, this is a Treasury publication, and I've pointed this out so many times. It's important. But you should be able to study this chart at the bottom of here. Study it to the point where whenever you see a trust instrument, or any instrument for that matter, that you can recognize it as a trust and you can write the proper abbreviation or syntax for the trust. Because when you start trying to title and use promissory notes and do different things with private equity securities on the private side, you're going to have to know how to track and register your stuff, and you're going to have to be able to present your claims and your certificates and things in such a way that they're recognizable in commerce. So I want to encourage you to really begin to study and kind of learn this, because to me, this allows you to look at any trust or identify any trust and write out the proper syntax. The same way, for example, if I gave you a name like John Anderson, the majority of people, because they're familiar with Romanized characters and syntax, they can syntax that into English. A trust under agreement, from my understanding, does not necessarily have to be in writing. It's under agreement. It may be under agreement between two parties. A trust under indenture would naturally be written. Let's see if they have. I think there is a such thing. Like, for example, here we got, or here's a trust under a will. Trustee under the will. Notice the abbreviation. So we got Thomas White, trustee under the will of Robert Smith, deceased. Thomas White, TR is the abbreviation for trustee. U/W is under the will. So we could look at this syntax and say, okay, here's the responsible party social security number at the beginning, by the way. Or you may say the identifying number for the trust, right? But it's going to be the tax ID number, social security number, responsible party number, identifying number for the trust. Here's something else. Let's look at one under declaration of trust. So a trust under declaration of trust may be different than a trust under agreement. A trust under declaration of trust is going to have a document. That's what I was talking about when I was saying under indenture. So look at the abbreviation. Paul E. White and Mary White, co-trustees. That's letting them know. In that syntax, as an account owner, that's letting you know that there's two trustees that are authorized on this account. Paul E. White and Mary White. And this is a good one that I picked because this is a family trust, which is probably one of the powerful trusts that you can be operating as your secured party. So it's under declaration of trust. That's what the UDT means. Dated 2/15. So using backward authentication, you would know that Paul and Mary White in their family trust was created on February 1st, 2005. That's the date that the trust was funded. That's probably the date that the trustees or the board of trustees signed all the documents and the trust was established. It's the trust under declaration. So you want to keep in mind that if you are using the syntax, they're probably, and you're using that a trust is under declaration, if your stuff was ever called into question, there should be a declaration relating to that date. So a lot of times you may want to understand that trust can be made under agreement. Constructive trusts sometimes don't necessarily have declarations and deeds attached to them. And all that being said, so knowing that a trust can be under agreement, under the will, under a declaration, right? And they have different syntax. We can go to, let's say, the UCC and perhaps understand how I can look at a certificate of live birth and comprehend that it is a demonstration of a trust. And the trust would have to be the Dojon trustee, whoever that is. And it might be anybody, just depends on who's doing the business. We're expressing a trust right here, and it is a living trust. You might want to call it a living trust. You might not want to. But I'm just trying to stick with their basic syntax. So this is a basic trust. Dojon, trustee, under agreement with, who am I under agreement with? The United States of America. Why did I say the United States of America? Because that's one of the parties. Yeah, that's one of the parties. It actually says that, not on this certificate, but it does. It does say that on one of my other certificates. It's interesting. I thought it was on here. They usually have it in a border. And I think maybe I don't know why I don't have the border on there. But anyways, the point is that there is an agreement. There's a trust agreement, right? Because you're not under a contract. You're not a slave, subject under contract. So there is an agreement. There's an agreement of public trustees of how they're supposed to conduct themselves. There's agreement to protect our rights. That is the agreement. Sorry for just clicking all over while I'm talking. Let me stop. And I know I'm clicking all over because, yeah, what I was trying to demonstrate, but it's not on here, but the Department of Health, the Ohio Department of Health is a part of the United States. And I think that you can understand, if you understand the administrative estate and things of the such, that this is an agreement. Oh, sorry. Let me get to the point anyway. Let me get back on track here. What we have here is Do John. The true name, the last name, the first name, the true name. Usually when you look at an application where they're asking for you to give credit or be the grantor of something, they're getting the credit from the true name, the one who has rights in property, real estate. So the true name, the last name, the first, who's the trustee under the agreement with the United States of America, because he's a creditor for the United States of America. He's not under indenture. He's not under contract. He's under agreement. Dated 5/14/79. Where do I get this date from? I get the date. And what does the date mean first? We should know what the date means by going back and looking at the trust registration statements, right? The Treasury guidance. The date means the date that the trust was funded, the date that the trust was established, created, or whatever. So in this particular instance, when we're talking about the estate trust, let's call it the estate trust, on this certificate, there's a date received by the local registrar. This is the date that I tend to use because this was the date that property was received by a custodian, which creates a trust because it's not his property, it's the date that he received the property. Now, that's why, so that is why the date received, not the birth date, but the date that this property was received, because this certificate is evidence of a thing that's done. So this certificates are for equitable purposes, from my understanding, but it certifies a thing that was already done. So the certificate certifies a record. The record is the trust. The record is the property received by a custodian, right? And what is the property? These items right here, what you see, 1, 2, 3, 3B, these are the items or the articles held in the trust. They've been captured and they're received here. So this is the process of what's known as de-evolution or devolution, from what I've been out. Again, go back and research this stuff that I'm saying. I'm recalling from what I've researched. When you get into the Land Registration Act, the Birth Registration Act, all of the things that's underlying the Minnesota Rule 220 title registration, we are talking about the de-evolution of real estate and rights in real estate, real property. We're talking about registering those things, making records of them so certificates and liens can be filed against them and they can be de-evolutioned into personal property, from real property or from real estate to real property into personal property. So certificates and liens can be recorded against them and they can be traded and credited and debited in an equity system, if you will. So the certificate is certification of a record. A record is an account of a thing done. The thing done was assets are held in trust. Those assets are what we focus on. That is where our security entitlement lies. So it's never that we're putting a lien on a birth certificate, although the certificate may be attached to the lien as evidence or as an exhibit. In actuality, we are putting a lien on the assets that are held or titled in trust. This being the trust, the record entry. This is a record of something that was done under the Birth Registration Act and all other acts requiring the recording of property. Property was received at a certain time. It's your claim against those assets. Why would you want to claim those assets? Because that's a security entitlement. That's where your credit derives in your Article 8 UCC filing. So anyways, so I hope you can understand now why I look at the certificate as evidence of a trust. It's like a trust certificate, evidence of a trust. You know, it's like a memorandum of a trust. You know, if you are a trustee in an equity proceeding, You wouldn't bring in a memorandum, you would bring a certificate of trust, right? This is the same thing. So this certificate is evidence of a trust. The trust is holding property, and this UCC is our registration of our security entitlement against the property or the estate being held, right? That's why I say is Doe John under agreement with the United States of America. Somebody may say, well, what's the agreement? I didn't say it was under declaration, and I didn't say it was under indenture. So I'm saying I can name a couple of agreements. Public Law 73, 1048, Stat 112, the Constitution of the United States of America, and the Bill of Rights and all of that. That is the public agreement. It is the agreement. Judges give consideration for it. That's why I have a public oath of office on a record. It's their contract with the public, right? So it's a contract trust to them. It's our agreement. And those agreements are the things the protections that government is supposed to accord to the people. Though that's what's agreed upon. That's why the people formulate a government. That comes out of an agreement. So that is the agreement that was formulated the date that they received this property. Is a constructive trust that we are now expressing. Now, I'm not saying it has to be done this way, but this is the way that I start out, right? Or if I wasn't going to use this, I would use the family trust. But there's other things you can do when you get into assigner and things like that, the assigner for the benefit of the creditor. You can still add other parties. But anyways, I don't want to make this forever. You can make your own determinations about this, that, and the other. So let's see. Let's get back to where we was. So I was talking about, sorry, let's go back. So we were talking about where to file. We said we're talking about the national filing, not the state filing. The state filing is where you will be doing your business. So that's where your bond will be put in place. Kind of like how most professional companies have EE&O insurance, errors and omissions. This is where you want to exercise your remedy, so you may have to put a bond in place for, to facilitate commerce where you live at, around you, where there is an absence of substance-backed currency and an absence of silver and gold. So that's how you're kind of like doing your business. That's where your secured party filing with the bond will come in, is to protect you and to facilitate commerce. But before you can access those securities, you have to have a claim or an entitlement. It's like clear chain of assignment, right? That's where your Article 8 security entitlement national record goes in, because we're talking about securities. That's governed by federal laws, and it covers all states. And we're dealing with trusts. So there's some private and public jurisdiction there. So we got to be in an international jurisdiction. So again, we said Puerto Rico or Maryland because they recognize international contracts. And as you see in the secured party trust registration statement, we're identifying a trust instrument that clearly has the United States of America as a party. But you are the trustee under that specific constructive trust. That specific constructive trust. So don't get it confused and be like, why would you be the trustee? You don't always, there's not just one. There's always a constructive trust for every piece of property. This is one of the things that I'm learning about an equity proceeding. There's a bunch, so these different trusts, and don't think just because the certificate has the name that your parents called you or whatever that it's yours, because, excuse me, you really shouldn't look at it that way. It's yours if you claim beneficial ownership or if you claim beneficial interest in it. Other secured creditors claim beneficial interest under your trade name or under the trade name. So kind of see it in those terms. It's not necessarily yours. And what we're looking at with this UCC filing is this specific. We're looking at this specific constructive trust that we just expressed right here is no longer constructive trust. Or maybe it is. It's constructed. But anyways, the evidence of it is the instrument. So let's get back on track here. I want to speed through this. So this is very simple. And if you read through this, it is simpler than it has been before. I've taken some things out because I realized at the end of the day that they weren't necessary and they were just delaying what would otherwise, or they were impeding on what would otherwise be a smooth process. Excuse me. So how that smooth process works is, first thing you're going to be doing is you don't have to authentic. Well, first do your QSIP search results. Do your QSIP search results so you can come back and get the QSIP number that shows what public security is being traded. So public securities have assets that back them up. That's what gives the value, in some regard, the value and the credit worthiness of that security in the public. So it's various assets. If people start pulling their assets out of a security, or if creditors start making claims against it, that security would lose value. Anyway, getting the QSIP number for securities issued off of your assets is helpful because, one, you now know who the fund manager is, who's also a custodian and a trustee, who you can potentially call for redemption of your note. Now, I think this is new territory we're talking about when we talk about calling for redemption of your note, or calling for the redemption of whatever security it is that you issued, not just a note, redeeming a bond, whatever security that was coming off of the estate for which you were the grantor or the beneficial owner of. So the QSIP information can give you a lot of information about that. With calls of redemption, typically you want to make a statement about the QSIP, and it's more evidence of the game is over. And it gives you also another trustee, because there's multiple trustees. You understand what I'm saying? Depending on, that's what I was kind of getting at before. For example, if you talk about a mortgage situation, you have the indenture trustee that's under the instrument, but then you have the trustees that are under that are assigned to the various different investment securities that are coming off of that. So don't get bent over, don't get bent out of shape over the fact that I've designated to be the trustee under this agreement. Because I designated to be the trustee is because my research has showed me by default they have me in a position as the paying agent. And I'm not saying that you want to be the trustee. That's not what I'm saying. But I'm saying you don't want to be just the paying agent with no other authority. As a trustee, you can appoint a paying agent. You can appoint someone else a paying agent. Not to get off the subject, getting back on the subject, the Affidavit of Beneficial Ownership, some people used to call this the Rule 220 Affidavit. And as you've seen, I'm clicking on this one, you've seen that was also in the UCC filing. This needs to be updated, and it will be updated. This represents the UCC-1 financing statement with the Affidavit of Title on top of the Certificate of Live Birth. This certificate may or may not be authenticated. Depends on how you feel about it. But the goal is this is to be recorded in the county with the affidavit on top of it. Now, this, if you notice, this template is a lot shorter now. It's nowhere near as long as it was. And it's because it's more precise, to the point, saying the things that are necessary to be said. So this is just to kind of show you what it will look like when you do the filing. It's a very short national filing, if you see, just a UCC financing statement. I hope I didn't confuse anybody. I did talk about the statement of accounting and all of that. You don't necessarily have to do that. But if you want to do it and you understand that, you can do that. But for lack of confusion, it's just very simple. The UCC-1 with the Affidavit of Title on top of the Certificate of Live Birth. Except these two things are going to be recorded in the county first. And once you get these two things recorded in the county with the page and the book number, then you will do the initial registration in Commerce. The trust's initial registration in Commerce. This trust right here. Right? That's its initial registration in commerce as a secured party holding property, and the assets are titled, page and book number, identified, recorded. They are accountable in the county, in accounting. So, yeah. Now, so let's go back over here. Things that I've learned. Tracer flag. Tracer flag, and I'm again, this is not legal advice. I'm just kind of speaking off of my research in this topic that not too many people discuss. Private securities, building private equity, private security interests. That's what this tracer flag is about. Tracer flag deals with a different type of account. And I want to say security entitlements falls within that umbrella, as would affidavits of commercial obligations that turn into commercial liens. Because those type of accounts those are type of certificates that and entitlements in equity that are based off of intangible assets. And when I say intangible assets, I mean, not based off of an asset like a house or a piece of real estate in a county, but somebody's trespass or somebody's violating your rights, or you enforcing and exercising your rights, which are intangible things but entitlements that you have. You're entitled to certain rights. So this would be an example of us executing, enforcing one of our rights, our right to beneficial ownership, our right to title and to own property. So this is an intangible asset for which we are building a security interest, which is a security entitlement under Article 8 filing. But since the nature of it is a private security interest that we're building, it's on a private side. So you put this tracer flag on there that lets the SEC monitor your process, from my understanding, which basically they're looking at all of the registrations, the places where you can register security interest, and you can create let's say you can create, not money, what's the term I'm looking for, but you understand what I'm saying, where you can create securities, basically, where you can create money of account. So they're watching this stuff because you can't use this private stuff to create money and start putting money in your straw persons and in your LLCs and your S corps and your businesses and your corporate debt. I believe you can start using this type of equity in private trusts. You see what I'm saying? So you got to keep this stuff on the private side, and this is what this tracer flag is letting them know. You will find the term speculation account. Speculation account is like a special account, special deposit, private side, common law, trust. See the frequency of it is the same type of thing. The tracer flag 15 USC, I believe, comes under the Securities Exchange Commission Act of 1934, which deals with private securities, government bonds, the Article 8 security entitlements that we're talking about, your principal interest, these type of things, these private treasury securities, not the public things. So again, you can do your own independent research on your tracer flag, but I pretty much come to the conclusion almost anything that we're doing as private security interests on perfecting our record so that we can title them and hold them in trust, we're always going to be using this tracer flag. But research it, and I would love for you to get back to me and let me know what your findings in. But the tracer flag isn't like the registered mail number, the tracking number that they use. No, they're always tracking. There's a page and a book number when you register things, different places. But the tracer is a flag, meaning that imagine somebody's looking at, they're monitoring stuff all day. Oh, they see this stuff. Oh, there's a flag on it. This lets us know this person is enforcing their rights. So they're building a speculation account. They're building an account that they're about to seize via some type of direct holding system or something like that. Anyways, to get a better understanding of what we're talking about right here, read that Article 8 in book entry security, the reference number 5 under the master file. Again, I said you got to go in and read these references. Again, I already demonstrated what the national filing is. It's really basic to the point. I'm just going further in depth so you can kind of get an understanding of what we're doing here. So let's go into, so we talked about the tracer flag. After recording, return to the trust. The trust, here's something else that's important. This is an affidavit. Affidavits, your common law record should have 2 witnesses on them. And because it's a notary, because it's an affidavit, you should also have a jurat on it, which is what a notary puts, subscribed and sworn, affirmed to on affidavits. But you should have 2 witnesses on it. Now, on the other hand, for instruments such as, like, say, a notice of redemption, and you don't even have to do it for that, but let me give you a better example, like a banker's acceptance, for that matter. I would suggest that since it's a commercial instrument, that you have one signature, authorized representative, which may be the authenticating agent, and then another signature for the treasurer or the trustee, and it may look like it's a witness statement, but I guess I'm saying on commercial instruments you just want at least one witness. That's your countersigner, right? If you're operating in trust, you at least want one witness on it. For your instruments, if you're in doubt, get 2. If it's a common law instrument, like it deals with the record, such as this really does deal with the record. Even though it is a commercial process, it deals with the record. So we got our 2 witnesses on here. But again, if it's just a commercial instrument, at least one witness, a testator. That's the person, that's your countersign, your countersignature. What happens when you sign it just with one person, you give it to a trustee, they countersign it and invest it into the treasury. So I say you can countersign it with your treasurer. You can sign it as an authorized representative and countersign it with the treasurer. But notice this is sui juris, right? So that's going to be a common law thing. You will always have 2 witnesses. Anyways, let's see. You can read through the verbiage in here. It has, for the most part, let's go ahead and read through it. I, John Doe, the affiant being duly sworn, declare and state the matters set forth herein. I have attained the age of majority on, you name the date, 18 years after the date of birth shown by the registered certificate of live birth, the certificate number, hereinafter certificate attached as Exhibit A. Make sure you attach the certificate. Make sure you write Exhibit A. I am the beneficial owner holding the title and interest in the above certificate, whose name also appears on the face of the instrument as John Alex Doe, by reference to the official certificate of live birth recorded and filed on the date received in the office of the local registrar, whatever county, as the same appears to be held for safekeeping as a state register. Yeah, I got that from someone else's certificate, that as appears to be held for state, but I think that's cool. You know what I'm saying? For me, it's about objective oriented. Let's get this stuff done. Lastly, I own the title and the rights to the property held in care and custody of the state registrar, evidenced by the above certificate as a valid trust instrument describing the property that is active trust estate conveyed unto I as the man. Then we name all the items or the articles held in trust. I am legally entitled and authorized to act, appoint, assign, convey, cancel, and execute said trust estate. No other parties are allowed without consent from entitlement holder, beneficial owner of record, and it is so ordered. Scribble, scribble, autograph, and you record this on your certificate, whether it's authenticated or not authenticated, and you want to have that recorded in the county where the assets are registered. Where was the assets registered? Sorry, flipping through again. Well, you know that by looking at the trust instrument. And remember, you know how to do the syntax for your trust instrument by looking at the reference 5, informations about trust. But this is a county. All of the trust instruments show the county, and they show the date that the items were received. So you want to make sure that you put your affidavit of title, affidavit of beneficial ownership, securing title to those assets, your encumbrance or your lien against those assets We want to make sure that that gets recorded in the county. Now, for example, for Ohio, I was looking because I was thinking, oh man, they're going to give us a hard time about recording an affidavit of title / affidavit of beneficial ownership. Actually, let me go to that real quick. I didn't say that. Affidavit of title and affidavit of beneficial ownership. These are two different things. This deals with the common law, the record side, affidavit of title. This deals with the security side, beneficial ownership. We're talking about the merging of the legal and the equitable title with this process. This securing the title on the land. Then we're putting the UCC commerce stamp on top of it as the non-UCC filing. But this is legal and equitable title, affidavit of beneficial ownership. Now, when you get into the, listen to what I'm about to say, key word, your county recorder's indexing manual. Ask your county recorder, maybe by FOIA request, if you can get a copy of the indexing and recording manual. Make sure you use those proper terms or you'll end up with something other than what you really want. And ask them how much you have to redeem under the FOIA request to retrieve a copy of their indexing and recording manual. I think you would be in your better interest to straight up come out your mouth or come out in your writing and straight up ask how much would it require, because it's a rather thick manual, and I think that'll just get you through some of the you're not supposed to have this type of thing. But anyways, I mentioned that because in that's where I learned, and I think that's uniform for all counties. That's why I became more persistent about the affidavit of beneficial ownership, knowing that it could be recorded, although many people have been rejected, because I started doing research on what the clerk is and isn't authorized to record and what they can and can't do, because rest assured, if they find any way that they can prejudice what you're doing, they are going to do it, and they're not going to tell you what justification they're using. So you got to get into where their authority comes from, what their guides and what their manuals is. And I tell you, if you get your hands on one of those, you're not going to have a problem getting anything else recorded. But that being said, your documents can have two titles, and I believe they can be indexed under two titles. But your affidavit of title, the reason why we use affidavit of title, and we're dealing with Ohio, so you got to do a little legwork in your own state. There it is right here, Ohio Revised Code. And I was doing the research to figure out what the clerk could and couldn't do, because I was rejected before trying to record an affidavit of title or affidavit of beneficial ownership on a birth certificate, like many. But in their statute, they call it an affidavit of title. So I was like, okay, but everybody else was saying affidavit of beneficial ownership. Well, title is on the common law side. Beneficial ownership is dealing with the trust and the security side. When I say common law, I'm talking about the republic or whatever where your rights are in the record, if that makes sense. So the affidavit of beneficial ownership is giving you title for the equity side. So I realized, I said, in the indexing manual, you can use two titles on a document, and this is this basically same thing in two different jurisdictions. You want title in the law, but when you're dealing with the securities, where there is no quote unquote money, just certificates and equity, you want beneficial ownership. So this says, I was researching what the clerk can do in my state, and I came across recording affidavit of title, an affidavit stating facts relating to matters set forth under Division B of this section that may affect the title to real estate in this state, made by any person having knowledge of the facts. Now, I know we just said, what, real estate. People kind of went, oh man, but they're going to say this isn't real estate. It is real estate, and you're going to have to figure out how to fight that battle or not fight that battle. And if you just, I got some suggestions, but I don't want to go into that and make this video longer than it has to be. But it absolutely is real estate. That's why I was talking about the Birth Registration Act and all that being the de-evolution of real estate into personal estate. That's what they were doing. They were making you register the real property, which is leaps and bounds and meets and all of that. Excuse me, that was the real estate. And then persons have interest in real estate. So then they were making that real property. Your interest in real estate is real property. And now once they do that, they start divesting. It's the same thing. This is a person. This is a part of that whole thing. Um, uh, oh yeah, that's why I was on that. Because this does deal with real estate. And when you take it one step further, it says the affidavits provided for under this section may relate to the following matters: age, sex, birth, right? All of that is related. We see this on the affidavit. We've entitled that. We put the sex, the birth, all of that is here. So this affidavit does relate to those matters. And it is an affidavit of title, right? They can't make judicial determinations, so we've corrected that. You understand what I'm saying? And at the same time, we've corrected by putting the tracer on here. We're creating a speculation account. We're doing some commercial things under security entitlements, and we're putting a claim in the equity jurisdiction by having the affidavit of beneficial ownership, which is serving a total separate purpose and doing a total separate thing in a different jurisdiction. So you see it's a lot of depth in here, and it's still simple. You understand? It wasn't a lot, but it's precise and to the point. Now we can spend a little bit more time on the UCC, because you got to get this done first. Every certificate, see, remember, equity is dealing with certificates, notes, debt instruments. The law is dealing with the record, trust indentures, affidavits, assignments. And those trust indentures, affidavits, and assignments under the law all deal with a person's rights in real estate, or the man's rights in real estate. So by the title and the registration of these assignments and things, they're involved in the, that this is the registration process. You know what I'm saying? So you're registering the property, but the property's not secure. You register the property so they can attach to it in equity. All of the claims that they make for money in equity, whether it's bills that they're introducing into law, whether it's securities that they're investing from your person based off of your signature, it all relates to personal estate, which is persons, or it relates to real estate, which is liens and encumbrances such as mortgages that they're putting against real estate. So it all goes back to the record. Basically what I'm saying is all their certificates and all of their equitable claims have underlying assets that they're attached to. And in the record is where those attachments are. For example, when attorneys foreclose, they always say based off of the powers that they received by you, and they point back to that deed that's in the record, which you're a grantor under, by the way. But the point that I'm making is you have to put the affidavit of title, beneficial ownership, on the assets in the county, the same county where they were recorded, so that you can make a record. You can have a page number and a book number on this before you title it in commerce. So before you can get the, before you can, let's say, before you can fund the account, the underlying assets have to be verified. That's why you want this page and book number on here. All right, so let's see. So let me go back to here. I know this is getting long. I just got to break down the UCC and we can be up out of here. But go down here if you have to, if you want to further understand about the de-evolution of real estate to personal estate on the birth certificate, or just understanding how, what you're really dealing with is land and real property, even though it doesn't seem like it when you talk about Birth Registration Act and affidavits of title. That is what you're dealing with. So some of this in here will help you with that. And let's see. So that being said, let's go into the UCC. We already talked about the trust registration statement. So this part right here, again, you have to go read that reference 5. You got to read Article 8 of the Uniform Commercial Code. because we're registering a security entitlement. We're also registering our trust with the Secretary of State in Commerce. Yes, I said it like that because I said it like that so you can kind of get a better understanding. Well, how are we doing that? Well, we're doing the UCC, right? Those are they manage those in the Secretary of State's office. You know, they're the custodians for the UCC filing system. The Secretary of State is, and we're registering as a secured party. We're using a Treasury syntax trust registration statement. We're not putting socials on here because they don't want you to put socials on here. They don't want you to put, tax ID numbers on here. So we're using a trust registration statement, and we're registering property indexed in that state. So we're registering it under a new secured party. This secured party exists. I got to talk about the foreign grantor trust. That's the other update. I'm doing that now. I'm applying for the proper tax ID number based off of this trust registration syntax. Don't worry about it if you already have a tax ID number. It's no big deal. I'm just going to always be fine-tuning and making things better. But anyways, initial trust registration statement. Where does this trust exist? On the record, you may ask. It doesn't. It's a private trust. You could put a certification or a memorandum of trust on record in the county with this trust registration statement, or you can just show up with a certification of trust in an equity proceeding if necessary. You know, and if you had to further prove that certificate, you can come in with your actual trust indenture, or you can execute a memorandum of trust. So the point I'm saying is most things that you're asserting in equity have to be proven on a record already. With the exception of this private trust, you could just use a trust registration statement and prove it with a memorandum of trust in real time if you don't already have one on the record. But more importantly, let's talk about the box 4 so we can be up out of here. Box 4 is, in this regard, we're not doing an Article 9 secured party creditor filing. We're doing an initial registration statement. Read that reference about Article 8. You have to do a registration statement if you're going to be titling your assets, if you want to be credited for your assets. But anyways, this is the initial registration statement. This record establishes the official book entry. My official books is the UCC filings and the assignments of the interests and the redemptions of the interest, right? This record establishes the official book entry and accounting for the attached document of title and underlying assets indexed thereto. This is going to be updated by the time you get this, but basically what we are registering is our security entitlement. It's the same thing that the Affidavit of Beneficial Ownership or the Affidavit of Title is as relates to the underlying assets, but in commerce we're going to register that we hold that entitlement in trust. We hold that equity in trust as an asset in commerce. So this speculation account, remember the affidavit's going to have that tracer flag on it, or this special deposit account, or whatever you want to call it, is going to be held by a trust in private equity. And it is this account that you can use to collateralize and to fund the trust's various operations. So anyways, we're clicking down here that this is held in trust. What is held in trust? The collateral, the assets, the underlying assets who now have a claim of beneficial ownership registered by page and book number in the county. Don't get twisted because you see this $7 billion and all of this. This is the actual, that's the public side, and that shouldn't really be on here. We're claiming title of the private entity. You could put the public information on here in parentheses if you wanted to, but it doesn't really need to be on here. Actually, we might put it on there. I'll think about it. You'll see how it's updated. But if it is going to be on there, rest assured it's going to be in parentheses to show the publicly traded security. But what we are registering is our principal security entitlement in the principal, the underlying asset that's making up that security. We didn't ask him to do anything with it. We're just registering title so that if we use that as collateral for something in commerce, such as to create a bond or something else, they have to verify who is the secured party on that account. And that's where this registration of the national filing, registering the security entitlement, and letting the trustees know and all of that stuff come in handy. So I hope that makes sense. Bailey, Baylor. Why? Because it's trust property. That's why it's Bailey, Baylor. It's trust property. That's simple. So there you have it. Let's see, is there anything else that needs to be said at this point? No, so it's a fairly simple thing. And I'm saying we pretty much concluding it. This pretty much concludes everything. Of course, you can ask questions. You have to do your own research but I will tell you this. One thing I'm learning is instead of doing so much research about what you're going to do if they don't file it, just give it to them, register mail, or mail it to them with the money order, register mail, restricted delivery, or whatever. Don't walk it over the counter and ask them to record it. Register it so they have to sign for it. And if it's done right, most of the time they're going to do it. Let them come back with an excuse and then research their excuse. So that was a pretty long video. And this concludes this. So the next time when we start talking about the master file, hopefully we'll be going into the secured party creditor filing, which everyone is waiting for. And we'll be taking a pause, going into some mortgage things, and finishing rebuilding the site. The site is being rebuilt, by the way. It's being rebuilt. Your memberships will carry over to the new site. Premium members, it's going to be, the new site is going to be awesome, right? So it's being built right now. So while I'm going to be taking some break, working behind the scenes, my team and myself included, we're going to be finishing getting all of this done, getting our affidavits registered in the county, getting our UCCs recorded, so that then we can go into the secured party filing.